Supplemental jurisdiction allows courts to maintain jurisdiction over claims that they would have no independent right to jurisdiction over. For example, Mary, a West Virginia resident, sues Mike, another West Virginia resident, for wrongful termination of her employment, a state law claim, in violation of the Americans with Disabilities Act, a federal law claim. The latter can get into federal court under arising under jurisdiction. It is, after all, a federal dispute. But the former, the wrongful termination claim, the state law claim, has no independent basis of gaining federal jurisdiction. The rules of supplemental jurisdiction, however, will probably allow the state law claim into federal court. In any case in which a federal court has jurisdiction, it also has supplemental jurisdiction over all related claims that are part of the same case or controversy as the original claim. In arising under cases, supplemental jurisdiction will even allow for the addition of new parties. In diversity cases, the rules relating to joinder of new parties are a bit complicated. Most civil procedure classes won't cover them at all, and we're going to talk about them again briefly when we get to joinder. Case or controversy, the standard for the purposes of supplemental jurisdiction, is generally understood to mean the same transaction or occurrence, or that it grows out of the same set of facts as the federal dispute. That is, the state dispute is part of the same transaction or occurrence as the federal dispute. The purpose of this rule is judicial efficiency. It seems wasteful or silly to allow a plaintiff to access a federal court to address his federal claims, but force him to a state court to address his state law claims when the underlying facts are basically the same, and sometimes even actually the same. The case or controversy standard is a bit looser than it probably sounds. All that's really needed is a factual connection between the claims, even if loose. So if the plaintiff brings a wrongful termination claim and an American Disabilities Act claim, and both claims relate to the termination of that employee, despite that the standards for each are different, the underlying facts that you have to prove are different, the elements of each claim are different, but the facts related to both are likely to overlap, that is likely enough to create supplemental jurisdiction. Let's take another hypo. Jack, an African-American resident of Alabama, and Bill, a resident of Alabama, get into a contract dispute. Jack informs Bill, probably not a good idea, but he does, that he intends to sue Bill for breach of contract. Bill becomes very angry. He attacks Jack, physically. And while attacking him, he speaks all kinds of unspeakable racial slurs. And the attack starts to look a lot more like a racial attack than it does an attack relating to the contract dispute. Do you see that whether Bill has violated contract law has nothing to do with whether he's violated civil rights laws? His attack on Jack, whether or not it was racially motivated and perhaps a violation of the civil rights laws, is entirely independent of whether there was a breach of contract. Perhaps the contract was Bill's motive. Perhaps the contract dispute, I should say, was Bill's motive. Perhaps not. Not entirely clear. But the two, regardless, have basically no relationship at all. The underlying facts that Jack is going to want to bring to the court to prove his claims, for one, and the underlying facts for the other, are really going to be quite different. Jack's civil rights claims are federal claims and will get into federal court under arising under jurisdiction. But his breach of contract claims are state claims. And because they arguably don't rise out of the same transaction or occurrence, Jack is probably not going to be able to get supplemental jurisdiction for his contract law claims. Take a look at 28 U.S.C. 1367C. Supplemental jurisdiction is discretionary. The courts have authority to decline supplemental jurisdiction when a state claim is 1. Novel or complex, 2. Would predominate over the litigation. Let's go back over those. First, if the claim is novel or complex, it's a matter of state law that would be unusual, that would require a different interpretation than prior courts have. The federal courts are going to be a little reluctant to get involved. 2, the state law claim would predominate over the litigation. The state law claim is so much bigger in the amount of material that the court has to digest that it just becomes the entire focus of the litigation. The federal law claim takes a back seat. The courts, again, are going to be reluctant to accept jurisdiction. They might have the right to, but will probably try to decline if they can. Courts will also decline supplemental jurisdiction when 3, the court has dismissed all claims over which it had original jurisdiction. For example, if you have a state law and a federal law claim in the same case, let's take the last hypo, the civil rights dispute and the contract dispute. Let's say for some reason the court decided to exercise supplemental jurisdiction. If the civil rights case was so obvious and the court just dealt with it out of hand, all that's left is a state law claim. The court is probably going to be very quick to dismiss that state law claim and send it down to state court. And there's also a catch-all. Number 4, Are there compelling reasons under exceptional circumstances under which a court might not want to exercise supplemental jurisdiction? It basically means what it sounds like. The courts have a lot of discretion here to do what they want to, whether or not to accept a claim. Next, we're going to move on to removal jurisdiction and wrap up the bases of federal jurisdiction.